Good evening, everyone. I'm Susan Drummond, City of Pasco hearing examiner. Today is December 9th, 2020, Wednesday evening, about 6 p.m. We have a pretty full agenda tonight. We have 6 items on the agenda. The first is actually a consolidated matter. It's the Big Sky Burn Road preliminary plat, involves both a Sipa Appeal hearing as well as a preliminary plat. That's followed by the Seven Sisters preliminary plat matter 2020-003. Then the Barker Ranch preliminary plat 2020-005. Then the Story Family Rezone matter 2020-006. And then finally, a special permit request from Riverview SDA Church matter 2020-012. I did have a question on the Big Sky preliminary plat. Look like that might take a little bit more time, although based on the updated plat map I received late this afternoon, perhaps some issues have been resolved. So I did wonder if that matter should, if we need to move that or if we should just proceed in the order. Did the planning department have comment on that?
And Madam Examiner, Jacob Gonzalez will address that question of yours, our staff, our senior planner.
Gonzalez?
Good evening, Madam Examiner. I think staff is interested in proceeding with tonight's items on both the appeal and the preliminary plat proposal.
Right. I was just wondering about the order, if we should hear the other matters first. I didn't know if sometimes on an appeal they can take a little bit longer. I know I have a number of questions on it. So I just wondered about the order, if there was any reason to move the order as it sets from what it set forth in the agenda and perhaps hear the matter last. That's all.
Yeah, I'm not sure that's necessary. I think we're okay with proceeding forward as the agenda lists today.
Okay. We will go ahead and proceed as set forth in the agenda with the Big Sky Burn Road plat going first. And of course, this is a consolidated matter with the SEPA appeal heard first, and then we'll move to the preliminary plat. On the SEPA appeal, the order of procedure is as follows. The appellant has the burden of proof on that, and they would present their case. That would be followed by the city and then any rebuttal on that. And of course, either the appellant or the city can call witnesses and so forth, although a lot of times it's just argument and presentation of various documents. And I have received the staff report on that and attached exhibits, as well as an updated plat map that came this afternoon. And then there was a memorandum or a brief that I reviewed from the appellant. And then with regard to the preliminary plat, planning department would provide a brief overview of the proposal. The applicant will then have an opportunity to present, and we'll open it up for public comment. Anyone who is present online may testify on the proposal. The applicant will have an opportunity to address any concerns which arise, and I may have questions throughout. I should note, of course, this is a remote hearing. Please don't use the chat function to submit any substantive comments. I will not be able to review it that way. Are there any questions on procedure on this? And it could make, I did want to hear from the applicant's or the appellant's representative in terms of order procedure. Sometimes on these appeals, it may make sense to have staff present a brief summary, particularly if there have been some changes on the proposals. It looks like have happened fairly recently, so the staff report could not have addressed those. If I could hear from you, Mr. Gonzalez, on that, and then also from the appellant's representative.
Hi, yeah, I think we're okay with letting, and Jeff or Craig, please feel free to step in if this is incorrect, but I think we're okay with letting the appellant proceed first in this matter.
Okay. Okay. Can I have the appellant's representative introduce himself, or if there's more than one?
Good evening, Mrs. Examiner. This is Mark Fickus of the Halverson Northwest Law Firm. I'm land use counsel to the owner applicant Big Sky. I'm in the office with Mr. Caleb Gonzalez. Caleb Stromstad. We'll both be presenting this evening, and I guess it would probably be easier. I have no problem with the order, but this will be a relatively significant presentation. I imagine I'm going to need a half hour to 45 minutes to adequately deal with the legal issues. I'd like to make a presentation on both issues together. I understand that the SEPA appeal is technically first and separate, but they're all interrelated to conditions of plat approval. So I'm willing to go right now, but I want to make sure that we're able to create the entire record that's needed on both open record hearings. So
that's fine on your question about consolidating kind of your argument and presentation. That's fine. It makes sense. They are very interrelated, and this is a consolidated hearing. It probably would be most efficient to present in that fashion. And that did go to my question about how long this would take. I should have asked you up front about that. Given what you've said about kind of the length of the presentation, I think it might make sense to kick this to the end of the agenda and to hear matter C, the Seven Sisters plat first, as well as the other matters, and then move back to the appeal rather than to keep everyone else waiting. I think that, because my guess is the other ones will not take as long, based upon what I've reviewed anyway. Mr. Gonzalez, any concerns with that? Oh, okay, if you can unmute, Mr. Gonzalez, I can't hear you.
We are okay with that process. That's okay with us.
Okay, so let's go ahead and we'll come back to the Big Sky Burn Road appeal and preliminary plat matter. We'll move now to the Seven Sisters preliminary plat. And I already provided a brief summary of how proceeding on a preliminary plat would go forward. But we'll start with the Planning Department presentation on this, followed, of course, by the applicant's presentation. Then we'll open this up for public comment. So I think with that, are there any procedural questions before we move forward on that?
No.
Oh, okay, hearing none. Mr. Gonzalez, are you presenting on this?
This is Jeff Adams. I will be presenting all four of these, C,
okay.
D, E, and F.
Okay. Mr. Adams, if you could state your name for the record.
Jeff Adams.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Thank you. And I can't see you on my video screen. Is there a way to pull you up so I can see you, or are you just proceeding through audio tonight?
I'm sitting about 6.5 feet away from.
All right, there you are. Okay.
From Rick.
I've got you on the screen now. You may proceed.
Thank you. This parcel is located between roads 84 and 90, just north of Burns Road. Parcel number 115170069. They are adjacent Columbia River Elementary School to the west, and then a little bit further down the road, Ray Reynolds Middle School. They're not shown on the map because it's a very recent development. The site is currently zoned R1, low density residential, and is part of an agricultural crop circle, as you can see on the aerial photograph. The site is approximately 60 acres. Applicant is proposing to subdivide their 60-acre parcel into 233 single-family lots. The proposed preliminary plat contains 233 single-family lots, which would have access from dedicated internal streets via future dedicated roads 84 and 90. And those roads 84 and 90 extend from the south of Burns Road. They're already in place. The lots range from 7,200 square feet to 12,000 square feet. The average lot size being 7,997 square feet. The proposal is consistent with the development standards of the R1 zoning district per PMC 2545050. And that's the summary for this plat.
Okay. I may have some questions, but I think at this point we'll move to the applicant. Is the applicant online?
He is, Madam Chair. Attendee is self-muted.
So if the applicant for the Seven Sisters 7HA LLC preliminary plat. If you could unmute yourself.
Okay, I am unmuted now, looks like.
Okay.
Can you hear my audio?
Yes, I can hear you. If you could state your name for the record.
Okay, Derek Alexander.
Good evening. Do you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Thank you. So Mr. Alexander, did you wish to add anything to the planning department summary of the proposal?
No, I think that's a reasonable summary. Is there a way to bring up video for me? I have a camera on, but I don't know if that's
Mr. White, Mr.
outside the
Funfar?
technology.
Yeah, is that possible, Mr. White or Mr. Funfar?
It's not, Madam Examiner. We do not have video for attendees.
Okay. Unfortunately, Mr. Alexander, it looks like we can't do that. I prefer it that way, but it looks like we're not able to do that. I did have a question for you. I just wanted to, I haven't looked at the staff report on this. There are a number of approval conditions which are in the staff report. Do you have any concerns with any of those proposed conditions? I think it's 1 through 9.
I did have just one clarification question on number 6, but the rest of them seem to be what I would expect as far as plats another plat that we've done in the city. So I don't know what the timeline is for clarifying that.
Yeah. So what was your clarifying question on number 6? This looks like a common area maintenance fee condition.
Right. The second sentence, or sorry, the last sentence states that the city will not accept responsibility for the landscaping abutting the street, and this would be referring to that along Burns Road until such time as all fees are collected for each phase that abuts the streets. And I'm just want to clarify, is that hopefully that's not the fees that they're discussing at the beginning of number 6, the common area maintenance fee, because that would not be collected until a house was built, until builders go, to building. So that could be a significant period of time depending on how they attack the phase and work towards I don't know if they'll start at the street or on Burns or back at the back. So I just wanted to ask the question, the fees they're talking about there, is that the common area maintenance fee or just general plat fees, construction inspection fees and the normal things that are paid at the time of plat submittal?
Okay, I'll ask Mr. Adams for clarification on that. It does, you're right, it does, that language just say all fees. And so it's unclear if it's all fees, the other fees that apply to the project or just this maintenance fee. Any other questions or concerns on those proposed conditions?
No, ma'am.
Okay, all right. So I'll come back to the question for Mr. Adams. But at this point, I'd like to open up for public comment. Is there anyone who is online with us this evening who would like to provide comment on this proposal? Mr. White, Mr. Funfar, I assume we've unmuted everyone who has called in on our side.
Yes, I'm not seeing anyone indicating they wish to comment.
Okay. Let the record reflect that there is not anyone who has indicated a wish to comment. So going back to you, Mr. Adams, there was a clarification on from the applicant on proposed condition number 6, and it has to do with this reference to all fees. Is that just to the maintenance fee, or is that intended to be broader?
Just the maintenance fee.
Okay, I'm going to insert the word maintenance in front of that, just so that's clear. Any
Great.
concern with that?
Nope.
Okay. All right, the only other question, it would be helpful to have a little bit more detail on the street and landscaping improvements. I don't necessarily need that this evening. I'm keeping the record open on all of these, the remote hearing matters, just in case there is anyone who's had difficulty calling in to ensure that they're able to provide comment on the proposal. Mr. Adams, would that be possible to provide just or either either from the planning department or from the applicant, just a little bit more detail on the street improvements, on sidewalks and landscaping and so forth.
We can do that. We can cite the code reference for that.
Okay, yeah, just a short memo. And from the applicant side, Mr. Alexander, I mean, that could come from your traffic consultant or the project engineer, a brief summary. That would be helpful for me, just more detail on the, and there are references to the code in here in terms of the improvements, but a little bit more detail on the sidewalk, street improvements and landscaping for the project would be helpful for me. Maybe it would be better from the project engineer, a short memo on that. Mr. Alexander, would it be possible for you to provide that?
Yes, we haven't selected an engineering firm. We've got a couple of bids in right now, but hadn't landed on a firm yet. So.
Okay. Well, then if you could provide a short memo, or whoever has the expertise to provide that, that would be helpful.
Okay, and that would be beyond
additional detail. Yeah, so additional detail on the width of the sidewalks, width of the streets, and the nature of the landscaping for the plat. Some additional detail on that, just in written form. And I do have the plat layout, so I have a pretty good idea. And there, of course, are the code references. But I think a short memo detailing all that.
Okay.
And so if they could have, like I said, the street width, sidewalk widths, and the landscaping surrounding the plat, and the improvements, frontage improvements being made, some detail on that, that would be helpful. Okay. If I typically will keep the record open for at least a couple days, would Friday, December 18th be sufficient time for that, Mr. Adams, Mr. Alexander?
Yes.
Okay, so I will keep the record open through Friday, December 18th to allow for that submission, but also any member of the public may submit comment as well on the proposal during that time period. The comment should go to the planning department care of Mr. Adams. He will then forward those additional materials on to me. And then a written decision will be out from me within 10 business days of the close of the record on Friday. Are there any questions for me on procedure?
Were you thinking of the 10th or the 11th rather than the 18th?
Yes, I was. I had my calendar turned the wrong page. You're correct. Yes, I'm sorry. The record will be kept open through December 11th, so 2 days from today. That is correct.
Thank you.
Thank you for correcting me on that. Okay, anything further on this matter?
So as far as procedure, this is new for me as far as we've done plats in a couple other jurisdictions, but the hearing examiner is new for me. So once you submit your decision, then that's considered an approved preliminary plat, and we can proceed with our development at that point.
Yeah, for there of course is the final plat and other building permits and other approvals that are required from the city. But for the preliminary plat, yes, it's the hearing examiner here in Pasco that makes the final decision on the preliminary plat. That is correct.
Okay.
Does that answers your question?
Yes, it does. Thank you.
Okay. All right. So we are finished with this matter. Mr. Alexander, you're certainly welcome to stay online and listen to the other matters, but we're done with this agenda item. So you are certainly not required to stay on the telephone. So I think with that matter is complete. We will now move to matter D, which is another preliminary plat. This is the Barker Ranch proposed plat, matter number 2020-005. Mr. Adams, I believe you are presenting on this as well. And of course, you remain under oath.
Thank you, Madam Examiner. This is the report for Barker Ranch plat. The parcel is located on the north side of Burns Road, approximately 1,300 feet west of Broadmoor Boulevard, and it borders Burns Road. The site is currently zoned R1 and is partly occupied by an agricultural crop circle and a deep gully to the south along Burns Road. The site is approximately 25.86 acres. Applicant is proposing to subdivide their 25.86 acre parcel into 101 single-family lots. The proposed preliminary plat contains 101 single-family lots, which would have access from dedicated internal streets via future dedicated roads 104 and 108 north of Burns Road. The lots range from 7,346 square feet to 12,724 square feet, and the average lot size being 7,911 square feet. The proposal is consistent with the development standards of the R1 zoning district per PMC 2545050. Just as a note, the Pasco School District owns the parcel adjacent to the west. It was previously designated for a future high school, but those plans are not firm at this time. A revised plat, which removes the proposed single-tier lots along the proposed 108 west border of the plat in compliance with PMC 1215 complete street policy, has been submitted for review, and that's the one that we're looking at on the screen right now. And that's the summary for this proposal.
Okay. Thank you, Mr. Adams. Do we have the applicant online?
We do, Madam Examiner, and self-muted Mr. Bowman and/or Mr. Fedoroff.
Mr. Bowman,
I'm here.
I'm sorry?
This is Stephen. I'm here.
And that's, if you could state your full name for the record?
So my name is Stephen Bauman. I'm with RP Development.
Okay, and can you spell your last name?
B as in boy, A-U-M-A-N.
Okay, thank you. And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I affirm to tell the truth.
Thank you. Do you have anything that you would like to add to the planning department's summary of your proposal?
Under the plat conditions, a few questions. Number 6, the question would be the same as Mr. Alexander raised on his Seven Sisters plat as far as the landscaping fees.
Let's see, let me get to that condition.
Number 6 is where that.
Yeah, I assume the answer, this is the exact same question. I assume the answer is exactly the same. And Mr. Adams, you correct me if I'm wrong on that. But I will insert the word maintenance in there unless I hear otherwise from Mr. Adams. If I do that, does that, I assume that clarifies that for you?
Yes, ma'am.
Okay. Any other questions or requests for clarification?
Condition number 8, not agreeable to that condition. I believe that it should read that utilities that need to be moved are moved by the owner of the utility. This is saying that it's a developer's expense, it's open-ended, and would require that we move any and all other, communications, power, all those things, to remove at our expense. And standard and normal is that if a power line or something that exists needs to be moved out of a city right of way, that it's the utility that owns it that moves it at their expense.
Are there any utilities that will need to be moved?
Unknown at this point, but there is that potential that follows the right of way that will exist along Burns Road. I know that there's multiple different utilities that are in that right of way. Big Bend Electric, Charter Communications, I believe, Ziply Fiber. Don't know that for certain, but there's definitely multiple ones that exist in those areas.
Okay. I'll ask for the planning department's take on that. Any other questions, concerns with the proposed conditions?
I can't think of any at the moment. John, do you have any thoughts on any of that?
I do not.
And John, did you, I don't have your last name. Did you wish to provide testimony this evening?
Yeah, good evening. My name is John Fedoroff. Last name is F as in Frank, E-T-T-E-R OLF. I'm with JF Engineering, and I am the engineer on the project working for RP Development. Just here for technical support mainly, but it's, I think Steve's stated it correctly. There are some
Let
existing-
me swear you in real quick.
Yep.
You swear to tell the truth and the penalty. You swear to tell the truth and a penalty of perjury under the laws of the state of Washington.
I do.
Thank you.
Yep. Sorry about that. Yeah, there are some existing utilities out there, power, fiber, possibly telephone, gas, those sorts of things. And I think Steve is correct that if we could modify 8 to read last sentence, the right-of-way must be relocated to a utility easement outside the right-of-way. And I think just period, and let it be figured out, you know, if it's the developer or the utility company that needs to get relocated, bear the expense of that cost to move that utility. As long as it gets accomplished, I believe the city is satisfied with that, should be satisfied with that.
Okay. I'll ask the city about that. Any other comments, concerns? Mr. Fedorov, anything further on the conditions?
I'm sorry, no, I have nothing further.
Okay, all right. Thank you. Before we open this up for public comment, I'll go back to you, Mr. Adams, and just ask a question on, I assume on condition 6, it's exact same as with the last matter and inserting the word maintenance before fees in the very last sentence. We'll address that question. And then there is this question on the payment for moving utilities, if any utilities need to be moved. If I could have your response to that, those two questions.
For number 6, we will agree with your comment that maintenance can be placed in front of the word fees. For number 8, we will take that under advisement and get back to you.
Okay. Yeah, and I'll be keeping the record open with this one as well. So, yeah, if I could have input on whether that condition should clarify at the outset in terms of how that payment will be or the cost of moving the utilities will be addressed, and whether that very last phrase should be removed or if it should remain. And if I could have input from both the applicant and the city on that, or if there's an agreement, that's always the ideal. But if there's a consensus on the wording on that particular condition, that would be particularly helpful. So at this time, I'll open this up for public comment. Is there anyone here from the public who would like to comment on this proposal?
Seeing
Mr. White,
none.
Yeah, go ahead.
Seeing none, Madam Examiner.
Okay, let the record reflect that no one from the public has indicated a wish to comment on this proposal. As with the last plat, also, I did have a question on the street improvement, sidewalks, and landscaping. If I could have a short memo, and Mr. Fedorov, you may be the one best prepared to prepare that, but just a short memo detailing street width, sidewalk width, and landscaping. And again, that is, there are code references in the staff memo, and I do have the plat, but if I could have kind of a written summary of that, that would be most helpful for me, if that could be provided.
Okay, we'll put something together for you.
That'd be great. Thank you. So I'll keep the record open for 2 days. That's probably sufficient, unless Mr. Fedorov, you'd like more time on that.
That should be sufficient. Thank you.
Okay, so we'll keep the record open through Friday, December 11th until 5 p.m. And if those my question and then the question on the utilities, if material can be provided to the planning department by 5 on Friday, and then Mr. Adams will forward those materials to me. And of course, anyone from the public who wishes to testify on or provide input on the proposal may do so as well through close of the record. And again, on this plat, as with the last one, my decision, written decision, will be out within 10 business days of the close of the record on Friday. Are there any further questions on this? Anything else I need to address on this particular matter?
So this is Stephen with RP. Clarification on what it is that you're asking. The code exists that shows all the stuff that you're asking for. So I guess I'm not understanding what a written summary, what exactly are we looking for?
Just detail the width of the streets that are being put internally, and sidewalks, and also the same with width of the frontage improvements and so forth. And so a short memo, this is 1 page, not very long, and also a summary of the landscape. And it helps to provide that in the record in written form, so I have that detail. And you are correct, there are the code references and so forth, and so you can dig through and sort that all out. But it would help me tremendously to have just a bit more detail.
Okay, and then as I'm reading through this number 6 again, it's a little bit confusing. And so the way that it has been, and it's been somewhat confusing and frustrating in the past, trying to understand what the city's intention is with this number 6 with the common areas, and when the developer's portion, when the developer goes in and gets that done and it's inspected and it's bought off by the city, traditionally it has become the city's at that point. And I'm just trying to understand and make sure that I'm understanding that that is the same, because the way this reads is the $475 is collected at the time that I believe that the permit is pulled to build the house.
Mm-hmm.
So if I develop a subdivision that has 50 lots and all but one of those lots sell, and the last lot doesn't sell for the next 20 years, the way that reads, I believe it says I have to do the maintenance on that city landscaping strip for the next 20 years. Am I reading that correctly?
Well, the way I'm reading it, and I'll need input from the city on this, is that the maintenance fee is paid upon issuance of the building permit. So once the building permit issues, that's or at the time it issues. So it's a condition of the building permit approval. And so regardless of whether the house ultimately sells or not, after that point, that would be irrelevant to the payment that would need to happen. And then it looks the way it does read is the city then, as a result, does accept maintenance responsibility for the landscaping. That's the way I'm reading it. Does that answer your question? If that's correct, and I'll turn to the city for that.
But that's after every lot has pulled a building permit, correct? So if one lot doesn't build for the next 20 years.
It's on issuance, the way it reads, it's on issuance of the building permit. And that would be typical for when fees are collected. So it's it needs to be paid with the building permit.
I understand that. So my question is, if one lot doesn't build for 20 years, as the developer, am I required, because the lot can sell.
Oh, right. You mean, so if the building permit never issues, you mean?
Correct. So am I responsible for maintaining this for 20 years?
Yeah, I don't think you'd be on. Well, let me actually. That raises an interesting question. So your question is, so you've got, say, a certain number of lots, they never sell, but there's an overall landscaping maintenance responsibility. How is that addressed? I guess that's. I'll turn to the planning department on that. For Mr. Adams, do you have comments on that in terms of how the maintenance fee works? Because I mean, you could have an issue if not all. I mean, the fee's paid when the building permit issues, but I suppose it could be possible that not all of the lots would be built at once.
Applicant is able to pay the fee and divest himself of the responsibility.
On building, whenever the building permit issues, is that how it works?
Or even before, if that's what he wants to do.
Okay, so it's either before or with the building permit for the individual homes.
That is correct.
Okay. Does that answer the applicant's question?
So not satisfactorily. So I would like to have an understanding of the city's position on why it's that way. When I get the street completed and I get the subdivision completed and bought off and brought to the standard that is required, then at that point it turns over to the city's, the city maintains the street after it's been bought off and turned over to the city. And I don't see the landscaping as it being necessary that be any different. There's still a maintenance, there's still not a maintenance, but there's still a warranty period that goes with you know, the subdivision and the landscaping as well. And I think that the landscaping, you know, it should be the same as the rest of it. It shouldn't be a complicated thing.
So rather than have a back and forth on this, I've noted your question. And if during the time that the record is open, if you could consult with the city on this proposed condition in terms of how it works, and then supplement the record with any additional comment or if any additional clarification is requested. I think that would be the best way to deal with your question. I would note, I mean, it is important to have a mechanism in place to ensure that the plat improvements, and in this case, the landscaping, does occur and is maintained. So I just keep that in mind as you're further addressing this particular condition.
Yeah, we've attempted for years and years to address this, and it's still in front of us today, and so that's the reason for bringing this up. Okay.
Well, if you're requesting any clarification on this particular condition, and again, I note if the language has worked to ensure that the landscaping is in fact maintained. I mean, that's a very important consideration in terms of the plat approval. But if there's some clarification or a different way of approaching this, please note that in your comment in the record. And again, I'm keeping the record open for 2 days until Friday. Would that be sufficient to address your question on this?
Not really, because I've tried for years to fix it. The code needs to be addressed to get it fixed sufficiently.
My role doesn't. I can't amend the code, but I certainly can consider your comments on this. I'll keep the record open a little bit further through, I think, let's say close of business Tuesday, December 15th. To address any kind of remaining questions, including this landscaping question that you have. So if you have any, if you consult with Mr. Adams and you and the city have a similar position on this, great. If not, if you can provide your comments and put them into the record by Tuesday next week, December 15th, then I will consider them.
Okay, and I would encourage this to be addressed with the previous plat as well. Just same type of issue, and in the past we've had the same issues. So yeah, we'll certainly get something together to put on the record.
So with regard to the previous, are you the applicant on the previous plat?
I'm not, but he's a fellow developer that we've collaborated, and we certainly communicate on challenges that we have had and issues that we run into regular, and this is one that we've had myself over and over with no resolution. So yeah, certainly a challenge that we need to address.
Okay, well, the record is kept open on the previous matter. So certainly if Mr. Alexander wanted to submit something on that, he certainly could do so.
Sure.
Yeah, so anyway, as I mentioned, the record on this is open through Tuesday next week, which is December 15th, 5 p.m. If the additional materials, including my question on the details on the landscaping, street improvements, can be provided, as well as the clarification on, I think there were the utility and the landscaping maintenance question, that would be appreciated. Any final procedural questions from any of the parties?
No.
Okay, all right, hearing none. I think with that, we are finished with this particular matter. And as with the last matter, the applicants for this, of course, you're welcome to stay online to hear the other matters, but we have completed this particular agenda item, so there's no requirement to do so. So I think at this point, the next item on the agenda is the Story Family Rezone, matter 2020-006. The order of procedure on that is pretty much the same as with the preliminary plat. Mr. Adams, you remain under oath, and I believe you're providing a summary of this matter as well, correct?
Yes, ma'am. This is the Story Family 5 rezone application. The parcel is located at 4011 Road 96. You can see it on the map there, on the overview map. The site is currently zoned RS20 suburban, and is developed with an earth-sheltered single-family dwelling unit, a garage, a pole building, and a horse shelter lean-to shed. The site is approximately 6.55 acres. Applicant is requesting a change of zoning from RS20 suburban to R1 low-density residential to facilitate a future subdivision of the property. Some background information: the site was annexed into the city in 2015 under Ordinance 4222, and zoning was assigned RS20 under Ordinance 4221 as part of that annexation. Ordinance 4221, which established the zoning, restricted the rezone of parcels, including the annexation, for a period of 5 years from the date of annexation. This restriction expired in June of 2020. And that's the summary for this report.
Okay, thank you. Is the applicant online?
Madam Examiner, I do not see the applicant.
Yeah, this is Caleb Stromstead. I'm
Okay.
representing the applicant.
Oh, okay, thank you. Good evening, Mr. Stromstead. If you could state your name again for the record.
Yeah, good evening. Caleb Stromstead, Octera Engineering.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
Yes, I do.
Thank you. Is there anything further that you wanted to add to the planning department's summary of the applicant's proposal?
Nope, I'm just happy to say on the record that I agree with city staff and their recommendation.
Okay. All right. I do not have any questions for you. So at this time, we'll open this up for public comment. Is there anyone who has called in online who would like to provide comment on this proposal?
Seeing none, Madam Examiner.
Okay. Let the record reflect that no one from the public has indicated a wish to comment on this proposal. I will keep the record open as with the other matters, just because we are conducting this remotely and it's possible someone could have had technical difficulties with calling in. Record will be kept open for 2 days through Friday, December 11th, 5 p.m. Anyone, including the applicant, any member of the public or the city, can provide comment that should be provided to Mr. Adams. To the planning department, they will forward the comment on to me, and then I just issue a recommendation on rezones. Council makes the final decision. Recommendation will be out from me within 10 business days. Are there any questions on procedure or anything else with regard to this matter from either the applicant or the planning department?
This is Caleb Stromstead. I would just ask the city staff if anything's added to the record that I'm included in that email transaction to Mrs. Drummond.
Okay, yeah, Mr. Adams, if anything comes in from the public, if you could forward that to Mr. Stromstead. And Mr. Stromstead, if I doubt we'll have any comment on this, but if it does and you find you need some additional time to respond to it, just make that request, and typically I will grant those.
Okay, thank you.
Yep. Okay, I think we are complete with this agenda item. And Mr. Stromstead, I think you may be involved with the other one, but otherwise there's certainly no need for you to stay online for the remaining matter unless you wish to do so. So moving forward, this is agenda item F. This is the special permit for the Riverview SDA Church. Mr. Adams, you remain under oath. You would like to present on this proposal?
Yes, ma'am. Thank you. This is for the church addition at 605 Road 36. This is a 3.04 acre lot, zoned RS12. Applicant is proposing to build a 9,500 square foot detached church and community outreach center, including a one-story building with fire suppression system, parking lot revisions, and site improvements. This has come before the hearing examiner before in October. At that time, there are two issues that were brought up. Issue number one was a boundary line adjustment consideration. The planning staff made it clear that the boundary line adjustment was not part of the consideration because it had not been filed at the time, and because the planning division would not allow for a boundary line adjustment for the sole purpose of avoiding development requirements. And then the second issue was the development requirements for Sylvester Street, Road 36, and West Irving Streets. That has been revised in the conditions of the report in number 12. It says curb, gutter, and sidewalk shall be installed in the property frontages along Sylvester Street, Road 36, and West Irving Street as part of the development of this project. Otherwise, the report is basically the same as it was last time.
Okay. I think last time so there's no SEPA appeal on this one, correct? Because there was a question about that, whether there was or was not. It said, my understanding based on what I've reviewed is there was a revised MD&S that was issued, but no appeal was filed of that. Is that correct?
That is correct.
Okay, yeah, and that's my understanding based upon my review of the materials, but I did want to check that. And then the 9,500 square feet, is that the church and outreach center combined? I wasn't clear on that.
It's a single building as shown on the map or the site plan.
Okay. All right, just wanted to confirm that. Okay, those were my only questions for you, Mr. Adams. Is the applicant online?
He is,
Yes,
Madam
I am.
Examiner.
Good evening. If you could state your name for the record.
Harvey Lighthouse.
Good evening, Mr. Lighthouse. Do you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
Yes.
Thank you. So this, of course, is a continuation. I remember we briefly discussed this matter, as Mr. Adams noted. Do you have anything that you wanted to add to the planning department summary of your proposal?
I had two questions.
Mm-hmm.
One was on the conditions of approval. Number 3 stated that a fire hydrant need to be installed, and there is a fire hydrant already on the property. My question is, does this mean that another fire hydrant needs to be installed on the property?
Okay, I'll ask for clarification on that.
It's in the photo on called corner entrance.
Okay, the existing fire hydrant.
There's an existing fire hydrant there.
Okay. All right. So yeah, so there's a question as to whether that condition's it may have already been met. I don't know, but we'll ask for input on that from Mr. Adams. Do you have any other questions or anything else you wanted to add about the proposal? Any other concerns with the proposed conditions?
So the other question I had was, I had made an appeal to the traffic impact analysis.
Mm-hmm.
So I didn't get a response to that. I see that it shows up in the approval conditions. Is that the answer to my appeal?
So I guess I heard from the planning department that a SEPA appeal had not been filed. And I know you indicated, I think, in the original hearing on this that one had been, but then there was a revised MD&S, and so perhaps that hadn't been appealed. So anyway, it sounds like there's a clarification on whether an appeal has in fact been filed on this. But then let's deal with your one question. So it sounds like that would be, is your question on condition 8, a traffic mitigation plan shall be prepared?
No, it is, well, that's the result of the traffic impact analysis. We'll see it. I think it is previously on the previous section, number 27, which is under...
The conditions I have are just identified as 1 through 15. So you must be, you're referring to the proposed findings, okay, not the project conditions. Okay, yeah,
So
27.
the traffic impact, go ahead.
Yeah, so that, it looks like those findings, it does state that a traffic impact analysis will be prepared. So it sounds like one has not been as of yet. But it doesn't look like that was then carried forward.
Yeah, it was.
I mean, there is the traffic mitigation that then results from that. The traffic mitigation plan, conditions 8 and 9 reference that. So so what precisely is your question then?
Well, I guess my question specifically is the appeal that I made, I never got a response back from the city, is now the condition of approval, the approval condition number 8, a traffic mitigation plan shall be prepared. Is that the response to my appeal?
Okay. So let me ask Mr. Adams for clarification on this, because I myself am a little bit confused. I guess before we open this up for public comment, Mr. Adams, do you have any comments on this? And I guess first off, was in fact an appeal filed? And what I have here is a revised MD&S that was issued September 28th. And I just want to clarify if that, you had said there was not a SEPA appeal on this. And of course, there are certain requirements. So city would probably be aware if one in fact was filed.
I have no formal record of an appeal.
But Madam Examiner, this is Rick White, and I can address Mr. Lighthouse's concern.
Let me swear you in very briefly, Mr. White. Mr. White, if you could state your name for the record.
Rick White.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
Yes, I do.
Thank you.
There is confusion on this because both finding 27 and conditions 8 and 9 are in error. They were missed. The traffic mitigation plan, I believe that the correct wording is not being used. We are not requiring an analysis of traffic related to this proposal. We have worked with our specialized traffic consultant, and the uses of the building will be posted per city standard inside the building, and that will be the guiding factor for traffic related to the addition. If the uses change, then we may or may not require some additional analysis or mitigation. But at this point, we don't see a traffic mitigation plan as necessary, or excuse me, a traffic impact analysis is necessary.
Okay, so it sounds like that's just an error in the staff report, and I should remove that proposed, or that should not be included, that's finding 27, referencing the traffic impact analysis.
Yes, and Mr. Lighthouse is certainly welcome to contact myself or our city engineer, Daniel Ford, and we can clarify that for him. Okay.
All right. Mr. Lighthouse, that I think answers your question. That finding 27, that was an error. And so that traffic impact analysis would not be required here. It sounds like the city has the information that it needs. And I think I do as well in terms of, because I make the final decision on this, of course. And there are conditions that do address traffic for this particular proposal. Mr. Lighthouse, does that answer your question?
Yes, thank you.
Okay. All right. Do you have any other questions, concerns with the proposed conditions?
No, I do not.
Okay. All right. So at this point, we'll open this up for public comment. Is there anyone who has called in who would like to provide testimony on this proposal?
Seeing none, Madam Examiner.
Okay. Let the record reflect that there is not anyone from the public who has indicated a wish to testify on this proposal. As with the other matters, we will keep the record open on this. And for this case, just through for 2 days, through Friday, December 11th, 5 p.m., anyone from the public and also, of course, the applicant planning department may provide additional comment on this. Although I do not, given the proposed conditions in here, I did not have additional questions myself. And then, of course, my decision on this will be out within 10 business days of the close of the record on Friday. Are there any further questions from you, Mr. Lighthouse, or from the planning department?
No.
Okay. All right. I think we have completed, thank you all for your participation on those matters. We have completed items C through F on the agenda. So at this point, we'll move back to matters A and B. And of course, this is a consolidated hearing on the Big Sky Burn Road preliminary plat, and it includes a SEPA appeal. If I could have, it sounds like we'll kind of consolidate these matters to a certain degree, but probably the appellant would go first for the appeal. If I can have the applicant's representative introduce himself. I know, Council, you would introduce yourself at the beginning of this, but if you could, I make sure that you're still online, since this took a little bit to get through everything.
Yes, Madam Examiner. Again, my name is Mark Fickes, Fickes. I'm a land use attorney at the Halverson Northwest Law Firm in Yakima, 405 East Lincoln Avenue. I'm here on behalf of Big Sky Developers to present both the SEPA appeal and to deal with some legal issues involved in the preliminary open record preliminary plat hearing. After thinking about it, Madam Examiner, again, just to keep, while they clearly are a consolidated appeal, I think the best way, after talking to Mr. Stromstad here, who's with me in the office, I think I'd like to make the presentation on my SEPA appeal, allow Mr. Gonzalez to go through his response, and then I'd like to reserve a few minutes of rebuttal at the end before moving on to the plat. I think that's the way the planning staff presented it, because Mr. Gonzalez bifurcated the issues. I think that's the easiest way to do it. The only one speaking on behalf of the appellant on the SEPA appeal. Although again, what we're arguing over is what conditions, if any, to impose on plat approval. So with that intro in mind, I'd be happy to be sworn in, and I think we deal with the SEPA appeal first.
Okay, that's fine, and that certainly is typical. So no issues with that, and I guess it will help keep the SEPA appeals kind of discreet, so I know precisely what's well. I've read the memorandum and so in the appeal, so I think I have a pretty decent understanding of what is issue, although that may have changed with the more recent plat map. So I think at this point, Mr. Fickes, am I pronouncing it correctly?
It's a Fickes, soft I, so Fickes.
Short I, okay. All right.
All right.
So Mr. Fickes, do you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Okay. So I will let you go ahead and proceed then with the SEPA appeal. And as I noted at the outset, I did receive a memorandum from you and have reviewed that.
Thank you, Madam Examiner. Again, I represent the owner applicant, Big Sky Developers, that is proposed what's before you today was originally 118 lot, 0 lot line duplex development in Pasco. Actually, let me back up. The original application was 112 lot duplex development. Prior to this hearing and prior to completing the traffic impact analysis, a slightly modified project was presented, which I understand the planning staff accepted, that included a half-street road A on the west boundary and increased the lots by 6 lots. So that's basically what SEPA was conducted upon. And the original, in fact, I went back and I reviewed your videotape from, there was an April 18th, the original plat hearing was scheduled on April 8th,
right,
with a subsequent appeal hearing. In fact, you caught one of the main procedural defects in the process. You recognized that while that was set for a plat hearing, the SEPA had not been completed. The city had not finalized a threshold decision. It is, as you know, it is inappropriate to conduct SEPA or modify a threshold decision after the primary government action, which is in this case plat approval.
Right.
So we have an appeal dated July 8th, that sets forth in general terms why we're appealing. And again, I'd just like to refer the examiner to the NDNS and there were 2 conditions that have been appealed. There's only 3 conditions in the MD&S, so this is a negative threshold decision, meaning the plat as proposed does not have a significant adverse impact on the environment. And we appealed 2 conditions. One was the original requirement for a traffic impact analysis, and the second was a fire mitigation fee. And I'm going to deal with both.
I have a quick question for you. The traffic impact analysis. Can I ask you a quick question?
Yeah.
So it's my understanding, based upon my review of the staff report, that the traffic impact analysis has in fact been submitted, and the city did not have issues with that. Is that correct?
That is correct. I'll let Mr. Gonzalez speak for it, but the traffic impact analysis has been done and has in fact been approved. It was paid for by the applicant and approved by the city. So that is the only relevant information on traffic that is before you in this preliminary plat hearing. So that is correct.
Well,
So
it'd be the only relevant information. I'm sorry. It'd be the only relevant information for SEPA purposes.
Yeah.
Different criteria for the plat. But I guess the question, if I could continue my question on this, for purpose of the SEPA appeal, if the traffic impact analysis has been submitted and the parties don't have a dispute over that, is this particular issue just regarding the traffic impact analysis? Is that moot since this issue has been taken care of? I mean, is there anything for me to decide on that?
It's generally moot, but I don't think the city understands the procedural defect of why it was illegal to ask for it. You can't, under SEPA, ask to study environmental impact after plat approval. So it's a procedural issue. Yes, it is essentially moot, but it's moot by happenstance. So the traffic, so simply, we just want mitigation measure number 1 doesn't need to be dealt with or incorporated. It's done. We accept the recommendations at page 20, but it was illegal to postpone. The city can't legally postpone traffic evaluation until after the plat hearing and after our appeal periods have run. The purpose of SEPA is to review environmental impacts up front. It was done, but at the time we appealed it, that wasn't necessarily the case. And by the way, studying something is not a mitigation measure. A request to go out and study something is not a mitigation measure. That's deferring environmental analysis. So I just wanted that noted, but basically number 1 is basically moot at this point if the city accepts it and doesn't incorporate any additional studies or mitigation measures.
Okay, so so it sounds, if it's moot, then I don't need to address issue 1.
Okay, all right, just remove. Well, you just need to remove it. You need. We win. It's removed. It's removed. Condition number 1.
If an issue is moot, then I wouldn't address it one way or the other. I mean, if there's a dispute on that, then then maybe I do need to address it. But if the parties agree that the issue is moot because the traffic impact analysis has already been done, then that takes care of that particular issue.
It will require a little wordsmithing. One of the conditions that the planning staff has asked as a condition of plat approval was incorporation of all conditions in the MD&S. So I just want to clarify that condition number 1 doesn't need to be incorporated in the MD&S. It was done. So
yeah, it'd still be there, but it sounds like that condition has been satisfied. So the applicant doesn't need to do anything more, at least with respect to SEPA, and in terms of providing the traffic impact analysis. That's my take on what I've reviewed, but.
Does Mr. Gonzalez agree with that?
Mr. Gonzalez, you'll have the opportunity to address this, but it's,
all right.
yeah, okay, go ahead.
Okay. The second issue is relating to a fire mitigation fee. And this sets forth a variety of complex issues in terms of when and under what circumstances a city can basically impose fees for future public infrastructure improvements. And again, I've outlined some of my legal concerns on my legal memorandum at pages 8 through 10. I hope the examiner has had an opportunity to review them. And basically, you'll notice that in my memorandum, the first argument, I was hitting a moving target. When I drafted this memorandum, I didn't have the benefit of the city's updated staff report. Normally, the only way to legally get around RCW 8202020, which, by the way, you know, as the examiner should know, and I think the staff should know, it says, no city or town or other municipal corporation shall impose any tax, fee, or charge, either direct or indirect, on the construction, reconstruction of residential buildings, commercial buildings, or in any other building space, and blah, 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 and then they go subdivision. So basically, you can't impose a fee, and in this case, what the city's purporting to do is we have 118 lot, or I'll get into it in the Plat hearing, maybe 123 unit duplex plat, and they're proposing to tax us $46,000 for a fire mitigation fee with zero legal support in the record. Now, the city of Pasco is a sophisticated city. It knows how to do this legally. It has school impact fees and it has park impact fees. They're in Pasco Municipal Code 3.45 and 350. It does not have any fire mitigation fees. This is the first time that myself or our client has run into this, and originally that is the only legal way to do it, and it requires a detailed ordinance and fee schedule that meets constitutional requirements. I think that Mr. Gonzalez, in his MD&S and in his appeal staff report, admits that in some respects he is no longer relying on an impact fee ordinance. What he is saying is he believes he has the legal authority to impose a tax under SEPA, and we're going to get to it. I'm going to have some questions for Mr. Gonzalez. It's really hard for me to question him in this format, but I'm going to ask the examiner to ask him some questions of record designed to see whether he can meet the constitutional standard. And under SEPA, the limited substantive authority under SEPA to impose conditions, the city has a burden to show that this particular development caused the need for the fee, and it has to be directly related to the impacts of the development. This is a plat within the city limits, it's within a fire protection district. There's nothing, adding 118 or 123 units doesn't do anything to the city's fire apparatus. There's no proof that we need a new fire station, that it's on the capital facilities plan, that the simple building of new homes that are consistent with the fire code require more fire improvements. I don't think there's any legal way to impose this $390 fee, which came out of nowhere and is based entirely on the city's interpretation of general policies. It's not gonna withstand constitutional muster under the Nolan, Dolan, and Burton analysis. So there, number one, there's nothing in the record to support it, although Mr. Gonzalez is going to try, but he's going to be facing an uphill battle. I don't see, in SEPA, I didn't see any comments from the fire chief, saying that it's required. I didn't see any comments that there's a new fire station built. I didn't see any detailed requirements on how to calculate a prorated share. They can't do what they're doing under SEPA substantive authority. So I think that is a wholly illegal requirement. And there's, again, no basis in this record. And I have, a few questions, and I'd like to reserve a few minutes to respond to Mr. Gonzalez, because I've read his report, and to be honest with you, I had a hard time following it. I really, I know he's in a tough position, and he maybe didn't have time to consult with Eric Ferguson beforehand. And by the way, I think the city staff may need to look at municipal resource services. There's a lot of information on this, but there's no ability to charge impact fees through the back door under SEPA, period. But the questions I would like the examiner to ask Mr. Gonzalez would include the following, and I'm happy to ask them, and maybe Jacob, I can re-ask them when you make your presentation. But what improvements would the fees pay for? I don't see that. Number one, are they on a specific approved capital facilities plan? Would be number two. Three, how specifically does this plat cause the need for the improvements? And then basically, I want them to the examiner. I think they fail the 4-part Burton test. What's the public problem that was caused by this plat? Does this plat make the problem worse? Will the money solve the problem? And is the amount proportional? It can't meet the Burton. I mean, it's hard to argue against something where there's nothing in the record other than the city wants some money. And I think it's patently an illegal tax. It would be overturned in any loop appeal or court hearing. There's tons of case law, not on a fire impact fee, and I've never seen a fire impact fee charged under SEPA without an impact fee ordinance. So I think the MD&S Condition 3 should simply be deleted as lacking any legal support on the record and any constitutional support. It just fails. So that's basically. I think mitigation conditions 1 and 2 should not be incorporated as a condition of plat approval. And I'm happy to answer any questions the examiner would have, and I'd like to reserve a couple of minutes to respond to anything Jacob's going to say.
Okay. Yeah, I don't have any questions for you right now, Mr. Fickus, on this, on the fire impact fee issue, and I do understand the arguments that you're making. It sounds like you may have a couple questions for Mr. Gonzalez, but I'm wondering if we should, and normally you could just go ahead and do that, and that's fine if that's how you'd like to proceed. But I'm wondering if perhaps it would make sense to hear from Mr. Gonzalez first, or from the planning department on this, in terms of kind of presenting their view of this. Any objections to that approach, Mr.?
Nope, no objections. That'd be fine.
Okay. So, Mr. Gonzalez, are you representing the city on this appeal?
Yeah, I'll certainly provide a general summary, and then I'll defer to legal counsel for the remainder.
Oh, okay. Do we have legal counsel online?
Yeah, yes, Madam Examiner.
Oh, okay. All right. If you could state your name for the record.
Yeah, Attorney Craig Briggs for the City of Pasco.
Okay.
Ferguson Law.
Okay. All right. What? So I guess just a quick question, Mr. Briggs. We had kind of an opening argument. I would kind of characterize Mr. Fickus's presentation. Did you wish to make any kind of opening statement or anything before Mr. Gonzalez proceeds?
Yeah, I would, Madam Examiner. I would, Madam Examiner. So I think I would agree with Mr. Fickus. Yes, the city, without a specific ordinance tied to a fire impact assessment, that we're without authority to do that. But I think that it is within the city's authority to mitigate environmental impacts, and specifically as they relate to the built environment, and that law's specified in the Washington Administrative Code. So I think that while certainly Mr. Fickus is correct that without a specific ordinance in place dealing with fire impact fees, the city would be on sure legal ground to move forward and assess fire mitigation fees that are again specific to the burdens that's placed from this specific development, Burns Road. And that's dealt with again in the Washington Administrative Code that allows for not just the natural environment mitigating those effects, but as it specifically relates to the built environment, and in this case, how that impacts the fire apparatus. And I'll let Mr. Gonzalez explain a little bit more detail about kind of what went into that to establish that number. But my understanding is that there was some documentation that was produced by staff concerning that mitigation measure under SEPA.
Okay. All right, thank you.
Madam Examiner, can you hear me? Can you hear
Yes,
me?
Mr. Briggs.
Madam
Yes.
Examiner? This is
Yeah.
Attorney Jeff Briggs, also Kurt Ferguson. And just very briefly, I had been tasked with addressing the traffic impact analysis. And my take on that is I tend to agree with Mr. Fickus that this probably should come during the threshold determination stage, because the agency is required under the administrative code. The city is to independently evaluate and consider mitigation measures when it's making that threshold determination. So the issue now, since it's already been issued, is does the reconfiguration of the lots, does that change the merit of the traffic impact analysis? And I would defer to Mr. Gonzalez on that issue as well.
Yeah, and I think my take on the traffic impact analysis is that issue's moot. It's done because it's all been taken care of. So I don't think I need to hear any legal argument on that. Correct me if I'm wrong, but I don't think sounds like that particular issue is moot from my perception. It sounds like the city's making a concession on appeal issue 2, which relates to the fire mitigation fee, and I can certainly hear from Ms. Gonzalez. But it sounds from the legal side, there's a concession on that, and if that's the case, then the appeal would be granted, and that condition would be stricken. That would be the result if, in fact, the city is conceding on this particular issue. Am I hearing this correct?
Madam
And
Examiner, just to be clear,
clarify one thing. Certainly, fire impacts do have authority to deal with those impacts through both SEPA as well as the preliminary plat process. I can't approve a preliminary plat unless issues such as, if it's not adequately supported by fire service, then that's an issue, certainly both under 5817 and the city's implementing ordinances, as well as SEPA. It sounds like the manner in which the city's approached this, the city's conceding, wasn't the best, and there certainly isn't much in the record in terms of SEPA on this particular on the fire issue. But is my understanding of what council has just stated, is that correct, or do I need is there clarification?
That's incorrect. So our position would be that while Mr. Fickus is correct that an impact fee could not be imposed without an ordinance, that's not what the city is doing. What the city is attempting to do is impose a mitigation fee under SEPA, under a completely different statute. And there is no specific requirement, as far as I can tell, of with regard to a specific code that needs to be in place, although there does need to be a policy that the city refers to and reference to an environmental document that shows those mitigation needs. And it's my understanding that the city had produced a mitigation fee assessment, was my understanding, based on this Burns Road development.
Okay, sounds like we do need. Yeah, go ahead. Sorry.
If I could just add one more thing, I think the idea that 118 unit duplex development wouldn't have any environmental impact with regard to our built environment is a little bit naive.
Right. So it sounds like we do need to hear then from Mr. Gonzalez on this. And I didn't, Council, I didn't swear either of you in just because you offered, I think, legal argument rather than testimony on this. But if you all did need to do that, I certainly can. If you did wish to testify, I could certainly swear either or both of you in. But I think at this point, why don't we move to you, Mr. Gonzalez, and if you could state your name for the record.
Yes, Jacob Gonzalez, Gonzalez.
Thank you. And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I do.
Thank you. So what did you wish to, or what did you wish to present on this appeal? And we're just dealing with the Sipa appeal right now.
Yeah, with regards to the fire analysis, again, just want to reiterate that the MD&S that was issued mentioned a fire mitigation fee, not a fire impact fee. And on page 3 of the staff report for appeal 2020-001, Again, it was reiterated that the fire mitigation fee of $390 that was indicated on the MD&S that was issued would need to be revised, and that staff has and is preparing an environmental document to identify the proportionate share of costs for a fire mitigation fee that could be allocated towards this particular development. So that again has been prepared, obviously not finalized, but that was identified on page 3 of the staff report that would be provided upon an approved preliminary plat for us to make that estimation by the Pasco hearing examiner.
Okay. Anything further, Mr. Gonzalez?
Not on the fire item.
Okay. All right. Yeah, and I think the other issue is moot. Is kind of my take, and I'm not hearing anyone dispute that. But so I think, Mr. Fickus, we are back to you. I think you had indicated you had some questions for Mr. Gonzalez.
Yeah, yes, Madam Examiner, Mr. Gonzalez. I just let me make a few comments. I appreciate the city attorney's comments. It sounds like they agree with me on everything other than whether or not the city can pose a monetary fee on this record without an impact fee ordinance, and whether they can do it solely based on their limited CELA substantive authority. I disagree with that. And by the way, there's nothing, this is the record tonight, and this is the frustration my client has. We're trying to get a plat that's probably out of the timelines of reg reform already completed, and we want a decision issued. We don't want the record left open. We don't want appeals left open. What Jacob Gonzalez just said was wrong. He doesn't, there's no open record to supplement and get additional environmental documents and change SEPA or update the fire impact fee or justification. He had a duty to put that of record today. And this is it. When we're done with the SEPA appeal, we're going to roll into a plat hearing, and we're going to ask the examiner to approve or deny it or condition it based on this record. There is zero authority for Jacob to scramble and go back and try to justify a $390 fee. And if the only authority is his general authority under SEPA to impose conditions of the plat, I think this record is devoid of any evidence, and he'll never meet the constitutional standard. But so those are legal arguments. Now, what I'd like to hear from Jacob, because again, my client feels like they're hitting a moving target. Again, the staff report, I received it Friday. I think it was issued Thursday. And he never provided any justification. I combed the entire Pasco City Municipal Code and couldn't find any justification for, I didn't see a new fire station on a capital facilities plan or anything, any SEPA policy other than general policies that would support it. And this would run afoul of 82020 anyways. But the questions I have for Mr. Gonzalez would be, again, what specific improvements would these $46,000 is $390 per unit fee? Well, here, let's go. How is it calculated? What improvements would it pay for? Are they on a capital facilities plan? And I'd like him to explain how it meets, in his own words. I know he's not an attorney, but their attorneys are free to jump in. How does this fee meet the Nolan-Dolan-Burton standard to show that it was the need for these fees were caused by this particular plat and are roughly proportional? And I think what they're I know what they're trying to do. They're trying to create a fund for a new fire station without appropriate approval. You can't use SEPA to require somebody to mitigate the impacts of future development. It can only be required to mitigate the impacts of this development. I don't think there's any impact at all on fire. And I don't think there, and whether it's on SEPA or the substantive authority in the subdivision code, I haven't seen, again, I've been doing this for 34 years. I haven't ever seen a city do it just right out of the top and say, pay me this under the substantive SEPA authority for some unspecified fire improvements. I don't care whether you call it fire mitigation fee or fire impact. This is an impact fee with a different name, and it's illegal. That's my position, And Mr. Jacob Gonzalez, I appreciate his staff report. It just doesn't justify what he's trying to do here.
So Mr. Fickus, that was a combination, I think, of both legal argument and possibly a series of questions in there. But I think the crux of what you wanted to ask Mr. Gonzalez was just if there's anything in the present record that supports the SEPA fee. Is my take on that correct?
Yep. That would be fine. That's a broad brush. Okay. This is his last chance to create his record.
Okay, so Mr. Gonzalez, if you could address that question.
Certainly, yes. An environmental document has not been included for the public record to review for tonight's discussion regarding the mitigation of a fire mitigation fee applied to this proposed development. Certainly, staff does not want to be in conflict with law here. We believe we are doing our due diligence under SEPA review. However, with regards to any legality of it, I'd certainly defer to our legal counsel again.
Okay. All right. So, Mr.
I apologize, Madam Examiner. I was under the impression
there was. Your name again for the record, just for the transcript.
Attorney Craig Briggs.
Thank you.
Law. So I was under the impression that there was a document. Hold on for just a moment here, entitled Fire Mitigation Fee Analysis and Estimate. My understanding was that was going to be made a part of the record tonight. That would again answer some of the questions that Mr. Fickus has with regard to the mitigation aspect. So I think that may be the point.
Hearing?
No, it was not.
Okay. All right. Well, I wouldn't be inclined not to admit it for SEPA purposes. Now, the preliminary plat, that's a different proceeding, but for SEPA purposes, it is on the record that the city created. So I would be inclined not to admit it for the purposes of the Sipa appeal. Though certainly for the plat, that's different and could be submitted that way. So any additional argument from council on that?
Your Honor, this is Mark Fickus again. Again, I guess we can address that in the plat, but I would actually disagree with you with all due respect. I would hope that the record, I don't see a legal basis to open the record and hold the record open on the preliminary plat unless there's
well, we have Mr. Fickus, we have a public hearing on the preliminary plat. So the public can testify. Yeah, planning department. I mean, the record is open. So anything that's relevant to the matters before me, and the preliminary plat is, it's a different set of rules that govern that. So the record on the plat, it's different than on a SEPA appeal.
No, I understand that, and I don't anticipate anybody being interested tonight. I'm just saying that the written records in the city. I don't think the preliminary plat record should be kept open to allow the city to propose additional documentation. I think the examiner is within her rights and jurisdiction to close the record tonight. We've been waiting for a long time, and we're hoping to finish the appeal of the preliminary plat as well.
I see. You're talking about, okay, that's we'll deal with kind of how long the record's kept open and so forth when we get to that, since we're kind of separating these or truncated these a bit, even though it is a consolidated hearing. But I understand your point.
Yes.
So I think I've heard everything from the parties, and I'll render a decision with the preliminary plat. But is there anything else that the parties wanted to say or present before we move on to the plat portion of this hearing? And I should note, I do have concerns based upon the record I received with regard to the approach to the fire issue.
Nothing further from council.
Okay. All right. So I think at this point, unless Mr. Fickus has anything further, and I understand all the arguments you've presented, so there's no need to repeat any of those, but is there anything else before we move on?
No, Your Honor, not on the SEPA appeal, and I'd appreciate Jacob Gonzalez's presentation of his staff report on the plat.
Okay. All right. Thank you all. I will take this under advisement, and a decision will be out with the preliminary plat. So at this point, we'll move on to the preliminary plat portion of this proceeding, and we'll proceed in the usual way with the planning department providing a summary of the proposal. And I, of course, reviewed the staff report and the attachments on this. And I did, by the way, I received an updated plat this afternoon, which I've printed out. So it looks like that is the current proposal, which I should be reviewing. Mr. Gonzalez, is that correct?
Yes, there was a revised preliminary plat rendering submitted today on December 9th. I'm not quite sure how to proceed with whether to discuss what was included with the hearing examiner packet, or the obviously staff has not had time to review what's before you today,
Okay.
what was submitted today.
Okay, yeah, it was, because it doesn't look like there were some significant changes on this in terms of the layout and so forth, which I think may address some of the city's concerns if I'm looking at it correctly. So, Mr. Gonzalez, why don't you proceed to do the best that you can? You can proceed on the materials certainly that were presented. If you noted that and you may not have been able to review this updated plat in detail just because of when it was submitted right before the hearing. But if it looks like some of the changes made address any of the city's concerns, if you were able to sort that at all, perhaps you could indicate that. So I'll let you go ahead as you, to proceed on your summary of this. And I did swear you in on the SEPA proceedings, so you remain under oath.
Thank you, Madam Examiner. So yes, just a quick summary. The proposal before you today, not this drawing, was 118 dwelling units with the zero lot line configuration on Burns Road, approximately 335 feet west of Broadmoor Boulevard. The site consisted of two parcels at about 13.15 acres. Through ordinance number 4327 in December 2016, it was approved for a comprehensive land use amendment from low density residential to high density residential. As designed and included in the hearing examiner staff report, the site would have access to Burns Road via 2 points at Road A and Road B, along with access points to Road A and B and D, with a average lot size of about 3,600 square feet. A public hearing was held on April 6th and was postponed for the completion of a traffic impact analysis. The staff report references the drawing, the preliminary plat that was included with that. And as noted, the staff had identified elements of the proposed design that do not comply with the Pasco Municipal Code, specifically concurrency requirements of 1236.050, parentheses 2, which is the extension of sewer. block numbered 1 through 40 exceeding the maximum block length of PMC 21-21-010 when measured from center line to center line. The frontage exceeds the block length by 43 feet. When measured through the back, it exceeds it by 290 feet. In PMC 21-10-020, the terms define block as a group of lots, tracts, or parcels within a well-defined or fixed boundary. Staff would interpret a fixed boundary to be the street center lines. Additionally, the width of the block under normal conditions shall be sufficient to allow for 2 tiers of lots unless there's an arterial present. That's identified in PMC 21-20-020. The blocks that encompass lots numbered 1 through 40 did not comply with that. Although the Burns Road today is not classified as an arterial, the 2018-2038 comprehensive plan indicates that Burns Road would be classified as an arterial roadway. So therefore, we are okay with that single tier of lots as proposed, that front on Burns Road. With compliance of Title 21, staff would see that the complete streets policy would be met. However, if the block tiers remain the same and the block lengths were exceeded, we would deem that as not compliant with the Pasco complete streets policy as indicated in Title 12.15. Lastly, with regarding the density, the plat as designed does meet the zoning requirements specific to the lot size. However, the 2008 comprehensive plan, which we are still operating under, signifies this land for high density residential development, which exceeds 20 dwelling units or an acre. We are required to obviously make sure that any preliminary plat conforms to the comprehensive plan map, text, or narrative. However, the 2018-2038 comprehensive plan, which was recommended for approval by the Pasco City Council on October 5th and awaits certification from Franklin County, has not yet been certified. So we're sort of in the middle of those 2 comprehensive plans today. So again, we did receive a revised.
Oh, just to clarify on that last point. So the density would be consistent with the updated or the most recent iteration of the comp plan. It sounds like there's a process involving the county certification. I assume that's true, that maybe the county-wide planning policies, that happens?
Yeah, the county must certify the comprehensive plan. We're not expecting or anticipating that until February of 2021. We just wanted to be thorough and identify that under today's comprehensive plan, it does not meet the density. However, we do have a comprehensive plan update that we hope is certified within the next few months, where the density would be compliant. Okay, because typically most jurisdictions, usually once the county adopts, that's the plan that is used. But it sounds like there's a second step there for you all. Okay. Yeah, the county has not made a formal decision on our comprehensive plan. Okay. Or I'm sorry, the city. I apologize. Once the city adopts, that would be the final decision normally. But yeah, please proceed, Mr. Gonzalez. I interrupted you. That's actually was the last item with regarding to the conditions of plat approval that staff wanted to point out. Again, we did receive a revised preliminary plat off quick look. It does look at addresses the block length non-compliance along with the 2-tier of lot, the sufficiency for 2 tiers of lots. With the row north of, I believe, Road B or proposed Road B. The other item that we would want to make sure would be that with the item that I believe you heard earlier this evening, there is a preliminary plat just to the west of this. We would want to make sure that the extension of any possible roads onto that proposed Road A would be compliant with the city's offset intersection requirements. I believe that's identified in the staff report. However, we just want to make sure that, again, that's on the record that we will be checking for that as well, which would be normal for any typical preliminary plat review. Okay, so just to clarify, and I know this is you haven't had much time to review this updated plat, but it looks, from what I want to make sure I understood you correctly, that it looks like this updated plat would have the 2 tiers of lots per block, the 21-20-020 requirement. The block lengths have been reduced, so they now meet the 1,320
foot requirement at 2120.010. Did I hear you correctly on that?
Correct.
Okay. All right. And then it looks like with the road C allowing for interconnection, it sounds, from what I heard, it sounds like that would meet the city's complete streets concerns that were identified in the staff report. Did I hear that correctly as well?
Yes, as a whole, the consideration for two-tier of lots, which our code requires, and the extension of Road C, we would deem as compliant with the complete streets policy.
Okay. All right. So that does take care of a number of issues. It sounds like there's a question on sewer. You mentioned that the sewer proposed on Road C does not extend to the eastern limit of the parcel. So it sounds like there is a question on the sewer. Perhaps the applicant can address that, but it sounds like that.
I believe, don't want to interrupt, but I believe that was also, again, hasn't been through a formal review, but I believe that has also been identified and addressed in the revised submittal you see today, or received today.
Okay. All right. All right, I may have a few other questions, but I think, Mr. Gonzalez, unless you have anything further, I think we'll move to the applicant's presentation.
No further comments.
Okay, thank you, Mr. Gonzalez. So for the applicant, Mr. Fickus, were you going to present, or was Mr. Stromstead going to?
This is Caleb Stromstead. I'm going to start. We're both going to present. I'll start it off though, Madam Hearing.
Good evening, Mr. Stromstead. I did swear you in, but it was on a different matter. So if you could state your name again for the record.
Caleb Stromstead.
Thank you. And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
Yes, I do.
Thank you. You may proceed.
Thank you. So I just wanted to go through the conditions in order. So condition number 4, it was discussed with the previous plats tonight about the utilities. And we have specific text.
Just pause for it. Let me get to the conditions here.
Sure. Page number 13, condition 4.
Okay, I'm there.
So our specific wording for this one would be as follows. First sentences would read, only city and other utilities with franchise agreements are allowed in the public right of way. The second sentence completely deleted. The third sentence can remain as it's stated. Overhead utilities shall be placed underground.
Okay. Can I have you?
We believe.
I need to take this down, and I can go back and listen to this. But can you restate that a little bit slower, so I can get it all?
Absolutely. First sentence: only city and other utilities with franchise agreements are allowed in the public right of way.
Gotcha.
And delete the second sentence in its entirety and leave the third sentence as is. And we believe the public works staff would have to obviously validate or confirm this, but we believe the intent is to take overhead utilities underground. The specific issue with this preliminary plat, it's hard to see with the grainy scan of our preliminary plat, but the 50-foot right-of-way that would be dedicated, or it might already be dedicated on Burns Road, there's an existing Benton REA trunk main, there's existing fiber optics, telecommunication lines, and possibly natural gas that are all underground per the city code. And so this specific wording would leave the applicant responsible to moving underground utilities just for the sake of getting out of the public right-of-way. And most likely where those utilities are right now, it's going to be in a landscape strip. So, but they have a franchise agreement to be in the public right-of-way. So we can't have the applicant or a condition that puts that, you understand what I'm saying? That condition has to be revised. Okay. So if there's any other questions on that, we can move on.
Okay. Yeah, all the planning staff can address, but yes, please move on.
Okay. The next condition is condition number 6. And the concurrency requirement and the reference PMC 1236052, that's in specific reference to extending utilities to and through the property. And our revised preliminary plat does show that sewer extends to the edge of the property, and that's what we understand that to be. And so that's been taken care of. We'd ask that condition number 6 be removed in its entirety. And the reason we'd like it removed in its entirety is because this entitlement process ensures concurrency. We don't want an open-ended, oh, we found out that there was another thing you're not concurrent with after entitlement and condition number 6 there, so you still have to do that. This is the time, if there's any concurrent issues, that it be dealt with in the conditions known. So we don't want that open-ended verbiage left over as a condition. So we'd ask that it be removed in its entirety.
If it's revised just to reflect that requirement on the sewer extensions, it sounds like what I'm hearing is you all have addressed that. If that condition were revised just to address the more narrow circumstance that I think was the one the city was concerned about, and I'll get confirmation on that, would there be any concern with that? And it sounds like I said, I know it sounds redundant because you all have already, it sounds like you all may have already met that, but just to confirm that is that the sewer extension is in fact required to consistent with 1236-0502.
The sewer extension and water extension is right. Required, and that's what's shown on the revised plat.
Okay. Okay. Yeah, you may proceed.
Okay, then the next one is condition number 7. Really, condition number 7 and condition number 9, those 2 conditions were met with our very original submittal, but we have a disagreement with city staff on that. It's a moot point to get into because we submitted this revised layout.
Yeah,
that I believe meets the intent of how the staff is interpreting their own code. And so for the sake of just not rehashing things that are unnecessary, the block length requirement referenced in the PMC and the block widths are all satisfied, and the street connectivity is satisfied. So conditions number 7 and number 9 are satisfied with this revised plat submittal, and I would like city staff to comment on that, because we would ask that they would be removed in their entirety, because there's no way that the hearing examiner can recommend any sort of approval with those types of conditions.
Yeah, it's a bit open-ended, and if in fact that does meet these requirements, and it sounds like what I'm hearing from the city is it does, then it would, what I do is just keep the record open so that that staff can take a closer look at that revised plat and confirm that it in fact meets these requirements. And then I think it probably would make sense to remove those 2 conditions if it already does that.
Thank you. And then the last condition is condition number 8. I would add, and Mr. Fickus is going to speak to this one in depth. From my perspective, I'm an engineer. It's my job to lay out these plats. We understand how the comp plan works. We're involved with that process, land uses, but we use the zoning code, and to require a density through the comprehensive plan has never been done to my knowledge in the city of Pasco. We've done a number of subdivisions.
Yeah, it sounds like there's just a quick question on that. It sounds like there's no dispute that the plat's consistent density wise with the zoning code. There's that language in the 2008 comp plan, but it sounds like the city's amended that. And actually, my understanding, it sounds like, is that with the updated plan, which the council's approved, and I understand there's this other process with the county certification, but that you all would be in conformance with the updated plan. Is that your understanding as well?
I have no idea what city staff wants, because that condition basically says throw this plat away and give us 3-story apartments.
And I couldn't.
No way to get.
Yeah. It would be difficult for me to approve a. Yeah, go ahead. Sorry.
Well, just my last comment. To get 20 units per acre here, we would need to have 263 units, and we are proposing 123. It's physically impossible to do public streets with duplex development at that density, 20 units or more is a 3-story walk-up apartment. And so it's really confusing why that's there. And it's also confusing that staff would recommend this be approved or denied based on accepting these conditions, because how can you approve a plat it's not a plat. We're doing an apartment site plan to get that density.
Yeah, I agree. It would be a completely different plat proposal.
So I'm hoping that we're all in agreement that that density thing can be eliminated, or that density condition, and we can be done. And then it'd probably be beneficial for staff to speak to these before Mr. Fickus goes, so we don't have to go down a rabbit trail if we don't need to. Would you agree with that, Mark?
Yeah, that'd be fine.
Okay.
Okay, yeah, that's fine by me. And then I needed to ask if the SEPA fire fee goes away. The other question that I have, and I have this from Mr. Gonzalez, is as well. Is there adequate fire service to serve the site? Are there adequate facilities to serve the site is my question. I'll ask Mr. Gonzalez about that. But Mr. Stromstead, do you have any comment on that? Mr. Stromstead, are you still there?
I was actually talking with Mr. Fickus. I thought you were talking to Mr. Gonzalez about the fire mitigation fees, and I did want to stay on track with those conditions, because that is kind of, I don't want to, what I spoke to I feel like was relatively simple, and if we could close the book on that, that would be very beneficial, and then open up the can of worms for the fire mitigation.
Okay, so I'm going to go back to, I will ask Mr. Gonzalez about because I can't approve a plat if their adequate infrastructure is not in place, or if there's new impacts that will exacerbate that issue. So I do want to have planning department input on that, and then I'll give you all the opportunity to respond to that question as well. So Mr. Gonzalez, I think at this point, there were comments on a number of the conditions. And we'll keep the record open, obviously, so you can take a closer look at the updated plat, can confirm compliance with these various conditions. But do you have any comment on the applicant's proposed revisions to conditions 4, 6, 7, and 9? And then there's my question on the adequacy of fire service to the site.
No, we don't see any immediate concern with the revisions or removal of those conditions. Again, staff would appreciate some time to actually review this process, or I'm sorry, the plat before us right now that was just submitted. But off initial review, we do believe that the Title 21 and Title 2012 concurrency requirements have been met. Of course, it hasn't gone through a formal review, so we would just appreciate some time to actually do that, to confirm that, and then would certainly be okay with removal or revisions to the conditions, including number 4 as identified by the applicant. Okay.
All right. Yeah, and I will allow that time. Do you have any comment on is there adequate fire facilities to serve this increase in dwelling unit number?
Rick, I may call on you for some assistance on that specific question, Rick, if you're able to hear me there.
This is Rick White, Madam Examiner, and the issue, I believe, is that the policy as approved by council, the location of the proposal is outside of the 6-minute response area. So are there adequate facilities? Adequate meaning, can a fire be addressed? My assumption would be that it can be. However, it may take longer for resources to arrive on the site than the adopted 6-minute response time.
Okay. Yeah, so my question there that was directed to is whether there needs to be anything added to the conditions if there is an issue with providing fire service to these new residents. It sounds like we may be okay on that. But I wanted to inquire about that. Okay. All right. So I think we've got some fairly decent clarification on this, and I think we've resolved a number of the issues that that were outstanding. I think I'll turn this back over either to you, Mr. Stromstead, or to Mr. Fickus.
I just wanted to ask one question. What's the city's stance on the density? Condition number 8.
Oh, right. Yes. Mr. Gonzalez, there is this condition here about consistency with the minimum density in the 2008 comp plan. Of course, if that were in there, I really couldn't approve the plat because that effectively kind of doubles the number of lots here. I get the concern that's identified here, but it sounds like the city has, in fact, the plat's compliant with the zoning code. And then in addition, the city sounds like it's moved in a different direction, and the plat would in fact be consistent with the comprehensive plan as it's been currently adopted by the city council. And I realize there is that added county certification process, but so does the planning department have a kind of position on the removal of that condition 8?
No, I don't believe there's I don't believe there's a concern with removing that condition. Again, we just want to point out that under the 2008 comp plan, which we believe we're still technically required to operate under, it would not be compliant with the land use densities of that comprehensive plan. However, we have an adopted comprehensive plan. It awaits full certification from the county and then review by Commerce prior to what we believe we can fully operate under. So the future land use map has not yet been updated would be the concern there.
Okay. And I guess, the way I interpret it, once the city council acts, typically and I haven't looked at the actual ordinance, but typically that once the city has adopted the plan, the updated plan, that is the plan. It sounds like there may be some local processes that have to occur. I know under the state law, Commerce doesn't have to approve anything. They have an advisory role, so there's no approval that's required there. They do comment, of course, on those plans and so forth. But if in fact the council's taken final action, then that would be the comp plan, I think, that would apply here. So I don't know. That's probably the way I would look at that. So, but anyway, it sounds like regardless, there's no objection to removing condition 8. So I think Mr. Strom said that addresses your question. So then, unless there's anything else from you, I guess the question is whether Mr. Fickus wanted to add anything.
Yes, I would, but I think there's been considerable clarification here, and we don't have as many issues in dispute with the city. By the way, I appreciate Mr. Gonzalez and Rick White's willingness to work with them. Let's start. I just have 3 issues I want to comment on: the road issue, the density issue, and the fire facilities. I'll start with the road issue. I wrote a beautiful brief thinking I was going to fight with the city over road extensions, and I don't think that's the case anymore. But let's talk about exactly what the examiner is being asked to approve. The map, I have no problem with Mr. Gonzalez needing some additional review time. But to be honest with you, this map you have before you with this new Road C being extended to the north and the 123 lots, that was designed to address Mr. Gonzalez's specific request. Attached to my memorandum is Exhibit B is an email from Mr. Gonzalez who asked for Road C. So I view what's being submitted is, number 1, consistent with the city's comments, and 2, I believe it is just minor modifications consistent with SEPA analysis and traffic impact analysis to date. So in the examiner's final findings and conclusions, we would certainly request, if the city would agree to it, that this new plat that was received, that is part of the record, be approved, that's what we're looking at. Now, by the way, if the decision was it wasn't going to be approved, we could go with the map attached to my memorandum as Exhibit A. But this new map not only solves the street connectivity requirements, which by the way, weren't legally required, but I'm going to leave that one alone. And it increases the density, which is what the city wanted. So, you know, I would like the examiner in her findings and conclusions, I think you have the authority to approve this slightly modified map meeting city requirements. And I would hope the city would agree with us on that one. On the density issue, there is some interesting legal issues. You've noted a few of those. I just want to put it as a land use attorney, I've gone through this process a lot of times before, and I think everybody's overthinking things. When I drafted the legal memorandum, we were under the impression that Mr. Gonzalez was recommending a denial of our plat because we didn't have 20 units per acre, which is physically impossible. And by the way, I sort of agree with Jacob on his confusion on this one. If you read the comp plan and try to compare it to the zoning ordinance, in this case, PMC 2570, the R4 density, there are some potential inconsistencies, but really they're not legally. As you know, under the old law, comp plans used to be a blueprint and zoning ordinances control. And after GMA, comp plans became more of a requirement, but the zoning ordinance has to be consistent, but only as to the zoning designations. If you look at PMC 2570, this property right now under the existing comp plan, and that Mr. Jacob Gonzalez has accurately commented on in 2008, is high density residential. It's a little weird having a high density residential designation next to low density, but it is. But remember what this property zoned. It is zoned high density residential. So we don't have to go any further than that. The zoning ordinance is consistent with the comp plan. And if you look in the zoning ordinance in the R4 zone, single family and duplex dwellings are allowed as permitting uses. And in 2570-050, the development standards, it has its density requirement, and we meet that. It's, you know, one dwelling unit per 4,000 square feet for single family and one per 1,500. We squarely meet all the development standards in the zoning ordinance. And
Mr. Fickes, just so you know, I'm not too concerned about the density. I think it meets code and it's consistent with the updated. But
all right, good. But as written, then the conclusions 6 through 10 just simply need to be written in the affirmative rather than a revised permitting plat be submitted. Findings should be made that this plat is concurrent on number 6. On number 7, that this plat does comply with all the development standards. Number 8, this does meet minimum density, and I don't know whether they're findings or conclusions, I don't care, but they need to be stated in the affirmative, not as we're going to submit some type of revised design. And then again, I think the complete streets policy has been met. And on your final comment, again, I'm just going to reiterate, we think there's adequate fire protection facilities. If the city wants to do a LID for a fire improvement district in the future, it can do that. But on this record, we think whether it's a 6 or 7 or 8 minute response time, our position would be that adequate fire protection facilities exist, and that the applicant certainly should not be charged a $390 per unit fee that nobody else has been charged on this record.
I will add, interesting enough on that mitigation fee, that wasn't stated on the Barker property.
Oh, yeah, and I didn't see it on the Barker property as well. By the way, that's a good point. I don't know if Madam Examiner caught it, but the Barker subdivision, this subdivision, the Burns Road, has been designed to integrate with the Barker Road. They're completely separate proposals, but the street systems were designed to address many of staff's concerns, and that we actually share Road A with the Barker Road subdivision that you reviewed earlier.
Yeah, and I will attest to that. I've been in contact with Mr. Federoff, and we've exchanged files, and so the revised alignment for the Barker Ranch streets that intersect on our shared road, those do intersect. So those, I made a note to comment on that because that was made during Mr. Bauman's presentation.
Okay. All right, Mr. Fickes, does that conclude And it is the revised plat that I am looking at. And I'll keep the record open so the city can take a closer look at that. I think I understand the nature of the proposed revisions to the conditions, which it sounds like the city does not object to. If you all did want to submit kind of revised language in writing, that would be fine. Although I do think I understand what the kind of the parties' respective positions on kind of the language. It's because Mr. Strom said you did a good job of articulating all of those. I
have one more thing to add.
Yeah, go ahead, Mr. Strom said.
The developer did ask me that there be a note there that this could be a phased development if they choose to. We didn't expressly show phase lines. At right now, there is no plan to do it all in one phase or do it in two phases. So we do want that option to develop this in phases. And I'd like that added into the conditions or in the findings.
Okay, if you could work with perhaps the city on some agreed language on phasing, just because it wasn't in the staff report. Because sometimes there are concerns about, on kind of the timing of infrastructure and so forth. So that actually might require some thought to how that should be worded.
I can work with Mr. Gonzalez on that. Does that sound good, Jacob?
Yeah.
Certainly.
Okay. All right. Okay. Like I said, I think I've asked, my questions have been largely addressed. I appreciate the parties kind of working through these issues because I think there's consensus, I think, on not all of them, but pretty close. I think I'll keep the record open a little longer on this, just to allow the city to take a closer look at the revised plat, which does look like it addresses the number of the city's concerns in terms of code compliance, but then also to address that question Mr. Strom said you had on phasing. I'm concerned that 2 days, even though that'd be kind of the standard, might not be quite enough. Thinking of keeping the record open through next week, Tuesday, December 15th. Parties have any concerns with that?
We're in agreement with that.
Okay. All right. Mr. Gonzalez, does that give you enough time?
Yes.
Okay. All right. So the record on this will be kept open through Tuesday, December 15th, 5 p.m. To the extent the parties can agree or submit kind of agreed further comment on kind of the revised conditions and any remaining questions, including that phasing one, that certainly is most helpful to me. And then, of course, at this point, we've had a lot of discussion. I don't think I opened this up for public comment to see if there was anyone present who wished to comment on the proposal. Is there anyone online who wished to provide comment on this proposal? I'm not hearing anyone. Mr. White, do you see anyone?
I am not. However, an earlier conversation with Mr. Bowman indicated that he wished to speak on this, if I recall correctly.
Mr. Bowman, are you online? Have you called in?
I'm here. I've been listening carefully and concur with what I'm hearing Mr. Fickus and Mr. Strom have to say.
Let me if you could state your name again for the record.
Stephen Bauman, RP Development.
And you swear to tell the truth under penalty of perjury under the laws of the state of Washington?
I affirm.
Thank you. And you just said you wanted to state your agreement with the comments that's been presented from the applicant. Is that correct?
Yes, I concur with Mr. Fickus and Mr. Strom and what they've been doing. We coordinate pretty carefully in our projects, try to be good neighbors, and I think that what they're saying sums up pretty well what our feelings are.
Okay. Thank you, Mr. Bauman. Is there anyone else who wished to provide comment? I don't hear anyone. Mr. White, do you hear anyone?
No, I do not.
Okay, let the record reflect. There's not anyone else who wished to provide comment this evening on this proposal. Okay, so I think with that, we've wrapped up with regard to planning department and applicant concerns on this. As I noted, records open through next week, Tuesday, December 15th, 5 p.m. And then a decision for me will be out within 10 business days. It'll be a combined decision on both the Sipa appeal as well as on the preliminary plat. Do any of the parties have any procedural questions for me?
None from the applicant.
Okay.
No.
Sounds like there are none from the parties. I think we've concluded tonight's agenda. Mr. White, Mr. Gonzalez, is there anything else that I need to address this evening?
No, I don't believe so.
Okay. All right. Thank you all. Appreciate your participation, and particularly on the last matter, the parties' cooperation on that. It is appreciated. We are adjourned.